Welcome to today's speaker series event. I'm going to be giving a brief introduction to our topic today, and I'd love to introduce our speaker to you. So here we go. My name is Valerie Londano. I'm the director of the Pre-Law Program of Distinction here at the King's Academy. And as all my legal advocacy students in the audience know, in order to effectively advocate for something, whether it's an idea or a topic or even for a legal right, one must start from a place of understanding. And so that's what today is all about. To speak up and defend your constitutional rights, you must begin with knowledge. So to help explore the contours of some of our most important constitutional rights, those embedded in the First Amendment, we brought in a true expert today. Professor Denise Harle hails from Tallahassee, Florida, where she is launching a brand new First Amendment clinic at FSU College of Law. I know a lot of you in the audience have applied for FSU, and so if you want to meet Professor Harle afterwards, ask any questions, you're welcome to do that. Professor Harle is a former colleague of mine and a good friend, so I'm especially pleased to host her on our campus today. She's well known and respected for her incredible litigation work and advocacy, especially on behalf of the unborn, because as a Christian, she believes deeply about the sanctity of life. I couldn't be more pleased that God has opened these doors at FSU for Professor Harle to start this exciting new program at FSU. I hope some of you someday might be able to be a part of it as you journey on your legal careers. And as a bonus, she has promised to look out for any King students that find themselves up in Tallahassee. Let me hit a few more highlights on Professor Harle's resume so that you can appreciate the rich background and the experience that she brings to this topic. Professor Harle earned 2 undergraduate degrees from Florida State University, followed by a master's degree from Stanford University, and her Juris Doctorate degree from Duke University Law School. She currently serves as a clinical professor and the director of the First Amendment Clinic at FSU College of Law, where she leads student advocacy and litigation efforts on free speech, religious liberty, and press freedom issues. Before entering academia, Professor Harle was a partner at Schutz & Bowen LLP in Tallahassee, where she was a member of the firm's appellate practice group, and she was a partner and practiced constitutional law. Before that, she practiced public interest law with a nationally renowned legal nonprofit focused on free speech and religious freedom for 6 years. Prior to that, she served as Deputy Solicitor General in the Office of the Florida Attorney General. Professor Harle has argued high-profile cases involving significant constitutional issues in both state and federal courts, including all the way up to the U.S. Supreme Court. She has plenty of other accolades from her accomplished career, including being nominated for a seat on the Florida Supreme Court. She's a frequent speaker and media commentator. You might have seen her quoted in the Wall Street Journal, the Washington Post, or the New York Times, or over on C-SPAN or Fox News. She's also testified before the U.S. Senate on matters of constitutional significance. So that gives you a flavor of her background, and before I hand things over, I want to briefly speak about the topic that we're addressing today. I invited Professor Harle here to speak about the First Amendment for future lawyers. Many of you in this room, I have no doubt, will launch into the legal profession one day in some capacity or another. And even for those of you who don't journey that particular path, all of you will play an important role in shaping our future generation. Whether as lawmakers or government leaders or just everyday community citizens, together you in this room will be shaping how we as a civil society understand, apply, and enforce our First Amendment rights. So it's imperative that we get this right. To kick off this topic on the First Amendment, consider the following quote. If there's a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. This quote comes from the Supreme Court decision in 1989, yes, Taylor Swift's era. But fast forward to 2025, you've probably noticed that we're living in a contentious time in society where offensive ideas, beliefs, people, and even institutions are quick to be canceled. I would suggest that today's cancel culture is entirely contrary to the Constitution, particularly odious to the First Amendment. Properly understood, the First Amendment actually stands for the notion that the more offensive the speech and the more disagreeable the statement or belief, the more deserving it is of protection. That's why today's topic is both timely and relevant. As we teach in the O'Keefe Pre-Law program, our rights to individual liberties, such as freedom of speech, freedom of expression, freedom of thought, of belief, and of religion, are God-given rights that are to be cherished. And if we believe that those rights are divinely bestowed, then we should stop at no end to protect them, to defend them, and to preserve them for future generations. The bottom line is this: whether we agree or disagree, whether views are popular or unpopular, we must find a way to unite in agreement that the right to live and speak according to one's conscience is part of our inherent dignity as human beings. So on that note, Professor Harle, we warmly welcome you and invite you to speak into this topic. Thank you.
Thank you so much. I think Ms. Landano just gave part of my speech. We did not compare notes, but we're definitely channeling the same line of thinking. Good morning, everyone. It's an honor to speak with you today. As Ms. Landano mentioned, my name is Professor Harle, and I'm the director of the First Amendment Clinic at FSU College of Law. As an attorney who litigates free speech and religious liberty cases, I've come to believe deeply in the power and the promise and the necessity of First Amendment rights. Today I want to talk with you about why the First Amendment matters, why lawyers play a vital role in defending it, and how the free exchange of ideas is essential to truth, justice, and a healthy democracy. I hope by the end you'll see yourselves, yes, even as teenagers, as participants in this ongoing mission. So what is the First Amendment? I think probably you all know because you have a fantastic pre-law program here, but the First Amendment to the U.S. Constitution protects 5 broad categories of expressive rights. So freedom of speech, freedom of religion, freedom of the press, freedom of assembly, and freedom to petition the government. These rights are not just abstract legal phrases. They are the foundation of a free society where ideas, even ideas we might find unpopular or offensive, can be voiced, tested, challenged, and debated. These First Amendment protections matter because, as one great believer in free speech, Frederick Douglass, observed, to suppress free speech is a double wrong. It violates the rights of hearers as well as those of the speakers. When speech is suppressed, whether by government censorship, social pressure, or intimidation, it's not just the speaker who loses. The audience, the community, the public at large loses too. Without free speech, we lose the opportunity to hear new ideas, to challenge the orthodoxy, and to grow as individuals and societies. So that explanation alone doesn't satisfy everyone. And not everyone buys into the idea that bad or harmful opinions should have a platform. So let's think about that. Why protect even controversial or unpopular ideas? There's a theory known as the marketplace of ideas that answers that question. So we protect unpopular ideas because we can't know in advance which ideas are true or which ideas might become important tomorrow. In a free, open marketplace of ideas, arguments can compete, people can weigh the evidence, and challenge various assumptions, and over time, stronger ideas will rise and weaker ones will fail. In his book On Liberty, John Stuart Mill famously argued that an opinion can fall into one of 3 categories. First, your opinion may be totally wrong, in which case freedom of speech is crucial because it allows others to present contrary evidence and arguments to correct your errors and to help you find the truth. Second, you might be partially correct. This is the most likely scenario. So where no side has a monopoly on truth, but by exposing the different viewpoints, it helps us to refine our understanding and combine the fragments of truth to have a more complete picture and to correct partial misunderstandings. Third possibility is you're 100% correct about everything. In this unlikely event, you still need people to challenge your ideas. You still need people to argue with you, because without having to defend your beliefs, you can easily just fall into dogma and forget the underlying principles. You risk holding on to that truth as a prejudice or an unthinking opinion without genuinely understanding the reasons why it's true. So Mill warned that when society silences dissenting voices, even those that deeply offend us, society deprives itself of the opportunity to reconsider and reaffirm what's true, what's just, and what's worth defending. That phrase, marketplace of ideas, itself came from a dissenting opinion by Supreme Court Justice Oliver Wendell Holmes in 1919 in a case called Abrams versus United States, where he wrote, "The best test of truth is the power of the thought to get itself accepted in the competition of the market." I'll repeat that. The best test of truth is the power of the thought to get itself accepted into the competition of the market. In other words, we should welcome controversial claims to see if they, in the end, turn out to prevail on their own merits. Free speech isn't just about letting people say what's popular. It's a humble approach because it means we refuse to assume that we're right about everything or that we already understand everything. Free speech is about ensuring that truth, justice, and understanding remain open, never settled, because they always depend on new evidence, new perspectives, and new conversations. You might wonder, if what matters is open discourse in a free and open society, why do we need lawyers or courts at all? And the answer is because rights don't defend themselves. Without attorneys and legal advocacy groups standing up for free speech, especially when it's unpopular, controversial, or offensive, the marketplace of ideas would be stifled. And without judges and courts with the authority to protect First Amendment rights, the free exchange of ideas could be lost forever. Time and again in American history, marginalized communities, religious minorities, slavery abolitionists, civil rights advocates, political dissidents have relied on courageous legal advocates to defend their right to speak, publish, organize, and protest. And these minority voices have relied on the constitutional guarantees in the First Amendment. When lawyers defend and the law protects unpopular speech, that doesn't mean that the speech is good or right. It means that in America, we trust the people, not just those in power, to test ideas, debate them, accept them, or reject them. As a lawyer, and specifically after many years now as a pro bono constitutional lawyer, I see daily how defending First Amendment rights often means fighting for the rights of people whose views we may disagree with, or whose voices we might find offensive or uncomfortable. But as difficult as that can be, that is precisely why stewardship of free speech matters. Again, from the famous Supreme Court Justice Oliver Wendell Holmes, he has another quote that I really like on this point. So he explained the First Amendment this way. He said, "It is the freedom for the thought that we hate." The freedom for the thought that we hate. And I think that's exactly right. Because the First Amendment, if it means anything at all, it's for everyone. That phrase by Oliver Wendell Holmes actually came up recently in a federal court hearing up in Tallahassee a couple weeks ago. Last month, you may have seen this in the news, a federal judge ordered that a law student from University of Florida named Preston Damsky be readmitted after UF expelled him for posting on social media that Jews must be abolished. Now, obviously, that speech was wrong and hateful and completely repulsive. But at a packed hearing in Tallahassee, Damsky's lawyer quoted Justice Holmes and argued about the freedom for the thought that we hate. Damsky's lawyer argued that, however repugnant the views, expulsion for expressing them likely violates the First Amendment because the university couldn't show that those statements were true threats of violence, and true threats being one of the very few narrow exceptions to the First Amendment's free speech protections. The judge agreed and issued a preliminary injunction requiring Damsky's readmission to UF law. Now, this example may make some of you cringe because the speech at issue was so awful, but that's exactly why it underscores that constitutional free speech protections apply, even when the content is deeply offensive. This is a real-life example of that principle, that hate speech still counts as free speech. That principle protects unpopular speech so long as it doesn't cross over into punishable threats, incitement to violence, or actual violence. And this brings me to another quote that I love and that I encourage you all to memorize. So it's from Supreme Court Justice Louis Brandeis in 1927 in his concurrence in a case called Whitney versus California. What Justice Brandeis said was, if there be a time to expose through discussion the falsehood or fallacies, the remedy is more speech, not enforced silence. I'll say it again because people talked differently 100 years ago. Justice Brandeis said, if there be time to expose through discussion the falsehood and fallacies, the remedy is more speech, not enforced silence. And the way I like to paraphrase that is this: the remedy for bad speech is more speech. The remedy for bad speech is more speech. You can see how that might apply in the case of Damsky, the law student, for example. Rather than send his anti-Semitic speech into an echo chamber of online chat rooms where others who hate people based on their ethnicity might become radicalized or reactionary against the silencing, we can let Damsky have the conversation, and others can respond and hope to persuade him that Jewish people, like all human beings, have a fundamental human right to live and to live with equal dignity. In other words, we counter bad speech with dialogue and public debate, not with government sanctions silencing certain viewpoints. In fact, historical research shows that in Nazi Germany, there were laws against making anti-Semitic statements, and those laws were enforced. Adolf Hitler himself was banned from public speaking in several German states from 1925 to 1927. But the suppression of ideas through law didn't work. It actually backfired, because people formed underground groups that radicalized and rallied against the suppressive speech laws. So the hateful ideas spread with even more force, and there was no healthy public counter-speech. The government can't stop hateful thoughts through speech suppression laws. That said, one of the gravest dangers to free speech is not always government censorship. Sometimes it is social pressure, peer pressure, or what I call strong civil discouragement. We all know about cancel culture. Being socially ostracized is a real punishment in itself. I bet you all understand that pretty well. When people fear being shouted down, canceled, or retaliated against socially or academically, sometimes in the college campus settings, for expressing unpopular views, many of those people simply choose silence. And there's good reason to think that this is a real threat in America today. The Public Policy Institute I work with at FSU, FSU's Institute for Governance and Civics, recently did a national survey on attitudes toward free speech. And we found some pretty alarming results. So in our study from September of this year, September 2025, 59% of respondents said that speech can be as harmful as physical violence. That's a majority of Americans that essentially believe that speech is morally equivalent to violence. And among Americans 18 to 29 years old, 20% said that physical violence is sometimes justified to silence harmful speech. Let me reiterate, that's 1 in 5 young adults in America reported condoning violence, sometimes to stop speech. So no wonder we often feel great social pressure to be silent. That hesitation to speak your mind, though, can be just as fatal to free expression as formal government censorship. Social censorship suppresses not only speech, but the very possibility of debate, dissent, discovery. It also impairs relationships. In my opinion, self-censorship that occurs because of social pressure becomes a huge obstacle to functioning as a healthy, diverse, democratic society. So perhaps the greatest tyrants today are not always the governments, but the invisible forces in our community that fear of backlash, that fear of exclusion, even fear of being misunderstood. As Frederick Douglass warns, liberty is meaningless where the right to utter one's own thoughts and opinions has ceased to exist. So when we allow that aggressive civil discouragement to silence people, even people we dislike, we weaken the marketplace of ideas. We rob ourselves of the chance to learn, grow, correct error, refine beliefs, and to see truth in new ways. And we even violate the spirit and the principle underlying the First Amendment. Now, you might say, Professor Harle, what are you talking about? I look on the internet and people are inflammatory and rude and totally shameless in what they say. Right? They're not centering themselves at all. In fact, society seems to reward those controversial rabble-rousers with huge social media followings. But I would submit to you that while, yes, some fringe outliers at the extremes do in fact speak their minds and say offensive things, and even get amplified online with, becoming cult followers and becoming popular in that way, the voices that we're sorely missing are a huge range of moderate viewpoints within that normal spectrum of reasonable opinions. Self-censoring often silences the polite, modest, conservative, thoughtful people the most. And those are the voices we need in our conversation. And that can't be entirely fixed by law. It has to be corrected through a cultural shift that abandons cancellation, embraces freedom of speech as a value and an ideal. And that's essential to civil discourse and civil dialogue that our nation was founded on. Let me say a little bit more about why that cultural shift is needed and what public opinion tells us. So today, nearly 235 years since the Bill of Rights was ratified and the First Amendment became part of our Constitution, many Americans believe that free speech is under threat. You might be one of those concerned citizens. So according to a 2025 survey reported by Foundation for Individual Rights and Expression, known as FIRE, who you should follow if you're a free speech fan, 74% of Americans said this year they believe free speech in the U.S. is heading in the wrong direction. Now, some of those Americans presumably also think speech can be as harmful as violence, so maybe there's some self-reflection lacking there, but the point is that Americans ultimately do feel and worry about the erosion of freedom of speech and civil dialogue. Another recent poll found that nearly 8 in 10 Americans think the country has already gone too far in restricting freedom of speech. These numbers matter because they signal that many people feel the First Amendment protections are slipping, or at least not being honored as they should. So that climate of concern, though, is actually precisely the kind of environment that breeds self-censorship and civil discouragement and legal overreach, because there's a general sense among people that speech suppression will be tolerated and will be gotten away with. In other words, that the First Amendment isn't doing its job. And so people say, why risk speaking up at all? As lawyers, citizens, students, future leaders, we should not ignore that alarm. We should pay attention and take action. That brings me back to my role, and potentially to yours. So lawyers and legal institutions perform a crucial service. We stand guard over the First Amendment, even and especially when speech is unpopular, hateful, or controversial. Legal advocates remind society that free speech is not a license to shout only when the crowd agrees. It's a guarantee that those with dissenting, minority, or offensive views have a right to be heard. Those who don't have mainstream views are exactly the people who need the First Amendment law on their side because they may end up defending their rights in court. This has happened over and over and over in America's history, including in recent history. Americans have had to fight in court to be able to live consistently with their conscience when it's not the majority view. The government actions involved in these cases often affect people of faith the most. In West Virginia versus Barnett, Jehovah's Witnesses had to fight to be free from being made to pledge allegiance to the flag when their religious belief was that their only worship and allegiance was to God. In a case called National Institute of Family and Life Advocates, NIFLA versus Becerra, in 2018, faith-based pregnancy centers fought to avoid being forced to advertise for abortion when it violated their pro-life beliefs and mission. California had been requiring those pregnancy care centers to post signs in their waiting rooms advertising for abortion, compelling their speech, contrary to their religious beliefs. Also, just a few years ago in Masterpiece Cake Shop, a Christian cake artist fought to escape punishment for refusing to create a cake celebrating a same-sex wedding ceremony, which was contrary to his biblical views. The state of Colorado was again trying to compel him to speak a particular message under threat of government punishment. There are so many examples of cases like this that have made it all the way to the U.S. Supreme Court because an American like you or me simply wanted to be able to speak freely and, according to their beliefs, without the government punishing them. The role of lawyers in courts is critical to ensuring these fundamental protections. But beyond that legal role, there's a civic role, a democratic role, a human rights role. As high school students, you are on the front line of the future of free speech. You will be parents, citizens, voters, perhaps even lawyers or public servants of the future, and you will shape the culture of discourse, either toward open exchange or towards fear, silence, and conformity. I want you to consider this challenge. What kind of speech environment do you want to inhabit tomorrow? One where only safe, comfortable speech is allowed? Or one where robust debate, even disagreement, is welcomed and encouraged? Let me close with one final thought from Douglas again, and then I will take your questions. Frederick Douglass said this: "Liberty is meaningless where the right to utter one's thoughts and opinions has ceased to exist." I know I mentioned this earlier, but I want that to sink in. We do not have freedom if we don't have the liberty to speak our own thoughts. That warning remains as urgent today as when Frederick Douglass first spoke. And as long as the First Amendment endures, so does the possibility of change, progress, justice, and truth. But only if we're willing to defend it. Your generation, high schoolers today, civic leaders tomorrow's, carries that torch forward. The responsibility is yours. Now, I can't promise you that courageously protecting the marketplace of ideas will actually produce acceptance of truth on all matters. But I can promise you that censorship won't. If you remember nothing else from today, I hope you remember this. Free speech is not just for people you agree with. It is for people you might oppose. Because in the clash of ideas, truth has a chance, justice has a chance, freedom has a chance. Thank you, and I'd be honored to take your questions.
Thank you so much. Okay, raise your hand if you have a question, then I'll bring the microphone around to you so we can capture that. Juan, thank you.
Good morning, how are you?
Great, good morning.
So I have a two-part question, I would say. So recently at the Oklahoma University, a student submitted a paper to a psychology professor where the professor raised a question about gender norms. She used a biblical source argument to battle the question the professor raised, and she received a 0. Now, the university has since placed the professor in a administrative leave. Now, the question is, have you seen recently, since I would say the death of Charlie Kirk, that universities have been prioritizing students' freedom of speech across America?
That's a great question. I'm glad you're following the news. I will just tell you a fun story. I set up a Google alert for First Amendment Florida when I first launched this clinic in August. And after a few days, I had to unsubscribe because there's so much going on in the First Amendment space, controversies like this. Having researched this area, this has actually been going on for a long time. So it's interesting that we're seeing, I think, some of the sort of Twitter calling attention to that incident, and sort of the public alarm is helping to protect the students' rights more than perhaps in the past. And that's a healthy thing, right? When we recognize, like, no, we can speak up and say, this was a suppression of speech, and the professor isn't always right. And then the state universities are arms of the state government, right? That's a public university that was essentially appears to have been punishing a student for their beliefs. So I wouldn't say I don't have enough data to say there's an encouraging pattern necessarily, but I will say that I'm tracking a lot of the sort of professor speech silencing cases, and there are several that are currently pending now that I think could clarify and fortify the law, because academic freedom has been acknowledged by the U.S. Supreme Court. It's sort of seen as part of the First Amendment, right, including the freedom of teachers and professors to speak their piece and for students to have their viewpoints. But the Supreme Court has never clarified a particular test with real sort of teeth to help understand how to be applied. And I think that the cases that are percolating now will give us some of that.
Okay.
Hopefully that answers your question.
No, yeah, definitely. And for not only myself, but all these future leaders that we have in this classroom gathered here today, how can us as young individuals create platforms where one can freely express their thoughts without any sort of social pressure to be potentially silenced?
Mm-hmm. I think one of the best things you can do is to know and understand your rights. So if you all are going off to college in the next year or two, you're going to want to look first and foremost at your college's handbook on free speech, academic freedom, codes of conduct, and familiarize yourself with where can I be, where can my group gather and have a table? Where can I put up a poster? Where can I wear a t-shirt? Can I protest this close to a speaker? Can I, host an event here? And what are the limits? More likely than not, the college and university probably has a legal code at this point, because hundreds of them have been sued or sent demand letters, and they've had to sort of correct their codes. So figure out, first of all, okay, where are all the ways in which I can freely speak and express myself and assemble, and then operate within that in a way that's winsome. My second role besides director of the First Amendment Center is the head of the Conscience Liberty branch in that Institute for Governance and Civics that I mentioned. And so that is all about freedom of thought and belief, civil discourse, and civil dialogue, and getting back to that idea that we can disagree without being disagreeable. And that is one of the best ways you can be heard, is to show that you are thoughtful and you're humble and that you care, so that your message isn't sounding like nails on a chalkboard to people because they already like you.
Thank you so much.
Okay, next. Another question?
How are our First Amendment rights grounded, like, biblically? Like, how do we know that we're applying God's law the best we can in our governments with the First Amendment?
Let me answer that by tying it back to what I just talked about with the conscience liberty. So when I think about conscience liberty, I think of a natural right, a morality, a human right that God gave us, as sort of like our Declaration acknowledges, right? We have these God-given rights. Every human being is born with that freedom of conscience. It's not something we get from the government, right? So what the First Amendment does is it codifies into constitutional law various ways in which that conscience liberty can be manifested. So freedom of religion, right, through the Establishment Clause, no establishment of religion, and the Free Exercise Clause, no prohibition on your free exercise of religion. Those are codified constitutional legal protections for that pre-existing God-given moral, natural right to a freedom of conscience. Same with freedom of speech. The free speech clause, that is a written down law that actually just is a guarantee, sort of a seal of approval on that pre-existing ability we have as humans to speak our mind. And so I think when you look back at what the founders did, it's frankly brilliant, right? To see that our society has existed in this way, in this free democratic republic, because they figured out a way to create these broad protections that codify, burn into law those pre-existing rights to your own thought, worship, expression, organizing those and associating with those you believe in. So I would say it's pretty well done. It would be probably hard to improve upon the First Amendment.
Thank you.
You mentioned cancel culture and social pressures to exercise your First Amendment right. What would you say in society and really my generation is missing that would take away this social pressure and this cancel culture in comparison to the founding fathers?
So I'm not a psychologist, but I feel like somewhere along the way, that idea that I talked about, that this sort of more common belief that words are violence, or that hearing something you disagree with is somehow going to hurt you, is what has created some of this social pressure and cancel culture. Is somewhere we decided we were not resilient enough as people to be able to be exposed to things we disagree with. Right now, that's kind of that's a very crude, generalization. But I think a lot of that is going on. There's a great book called The Coddling of the American Mind by Greg Lukianoff and Jonathan Haidt that talks about this shift, right? It's great. We started caring about self-esteem and started caring about emotional health. And then all of a sudden it was let's make sure nobody feels hurt or feels sad. And that, I think a lot of people bought into that and started wanting to protect anyone from having to hear things that might offend them or might hurt their dignity, right? Whereas sort of the growing up, sticks and stones may break your bones, but words will never hurt you. In the 80s, when I was a kid, that's what we believed. So I think part of that is really it's going to take that cultural shift of you all being willing to be the leaders on, no, I can hear things I disagree with, right? I can debate that. I can engage with that idea, and I'm not threatened by it, and I don't need a safe room, and and I'm not devastated by the fact that someone disagrees with me.
Do you believe there's a time when freedom of speech becomes not protected, and when? When is that?
Yes, I believe it because that's the law. So there are categories that are not free speech, right? So true threats, as I mentioned in this speech, incitements to violence, fraud, defamation, perjury. There are a way in which you can have your speech can essentially become criminal conduct because either someone is relying on you and you're essentially taking money from them, or with a true threat where you're actually saying something that is imminently triggering and abetting violence very clearly. It's a high threshold. Those are narrow carve-outs.
And so with the Damsky case with Jews must be abolished, how do we decipher if that is a call to action to violence and whether it's protected or not protected?
What the courts look at is sort of the specifics. So if there were an example where someone said, these particular individuals, all right, let's say they posted on their Substack or something, right, and said, this is their address, you all need to go do something, we're all gonna get together tomorrow at noon and bring your weapons, and these are the people we're going after. It would have to have more tangible factors you can point to where there's like a plan for criminal conduct.
Okay, thank you.
Okay, and so as a professor at a public university, how do you feel talking about especially controversial topics like abortion? I know you worked on the Roe v. Wade case. How do you feel about your future in free speech, especially talking about controversial topics like that?
Yeah, that's a great question. I did not work on Roe v. Wade. I was not alive in 1973, for the record.
Yeah, well, like
But
the
yes, I know
Supreme-
what you meant.
yeah.
I know what you meant. So I will say, and I think statistics back me up, that overall ideology among university faculty is very heavily more progressive and liberal views. So to me, I am excited to be a voice where maybe a lot of the students can relate to me in a way that they maybe didn't feel like they shared some viewpoints with a lot of the other faculty on certain issues. What I do, though, is I never tell my students how, really like how it should be, right? My own personal opinions. I teach them the law. I love having debates about, is it this way? Should it be this way? Okay, what's the counter argument? And I tell them very clearly, I'm not going to grade you based on whether I share your opinion. So to me, it's kind of creating that safe space, not really leaning in too much to my own personal opinions, but mostly teaching the law. And if someone wants to come to my office hours and have more specific conversations about like my previous work or sort of a career path, if they want to work in some of the same nonprofit areas I did, they know that's who I am, and I can mentor them that way. But I'm such a big believer in civil discourse and that variety of viewpoints that I'm very reluctant to sort of lean into my personal political views.
Thank you.
Mm-hmm.
How you doing?
Great.
If a harmful radical view is gaining popularity, attention, and speed without a countermeasure expressed in a similar capacity because of social silencing, should the government have the right to intervene? And do they have that right?
No and no. Yeah, it's on us. I mean, and I think the founding fathers, the framers of the Constitution and the Bill of Rights really entrusted the citizens to do the right thing and have character and really kind of believe that in the end, in the long game, truth is going to win out, right? And so we do see pendulums swing on certain ideas, right? Like to give like another sort of controversial example, there was a real push for many years about doing various medical procedures on minors who were struggling with gender dysphoria. And I think we can see that a lot of people were afraid to push back on that. But ultimately, there has been a very significant pushback with states protecting minors from gender transition procedures. But for a while there, that was not, you couldn't really stick your head up and question that. So I think we trust that people will have the courage and will live out the courage. But the most dangerous thing would to allow the government, people in power, whoever they might be, to impose their viewpoint at that moment on everyone else and sort of dictate what the national conversation is.
So they should be a neutral facilitator.
Essentially, that's right. I mean, it gets a little complicated in the dialogue, and if you're around for lunch, we can go into more of the nuances. There is a concept called government speech doctrine where the government can promote certain messages, right? So, I mean, because the theory is the government is a reflection of the people, right? So we elect the people into office. We voted them for a certain reason, right? We may have certain agendas we want them to execute, and they're allowed to have a state motto, or, of course, the governor can make a speech and promote certain things that he or she believes in. So I wouldn't say like strictly neutral in that sense, but once it gets to the point of either compelling speech or banning speech, that's where the government is out of bounds.
Thank you.
Mm-hmm.
So a great question, guys. Okay, we've got time for a couple more. Tucker, I'm coming to you, and then Drew or Ryan.
So in modern society today, you've seen a surgence of violent protests and violent insurrections. Namely, like this week, we had the violent protests against ICE in New York and things like that. Do you think that with protesters starting to turn to an idea that they have to be violently radical in their beliefs and approach to get their message out there and to be heard, do you think that that's going to make it harder for more peaceful protesters, more reserved protesters who just want to see change and not necessarily violence to make their message heard?
Yeah. I hope not, but you're hitting on something that's really important, which is there's a difference between speech and conduct. And sometimes law enforcement or government officials or even courts have had trouble drawing that line, right? Either they're wanting to be overly protective of speech or for whatever reason are not enforcing the laws against violent crime. And that is when we see even more danger because if you're allowing sort of violent speakers to be vocal and hurting people or hurting property, then you can really understand why the other side that disagrees with them is afraid to do a peaceful protest or is completely drowned out by the chaos on the other side. So it's absolutely critical that our actual laws against violence and damage are enforced. We don't need to regulate the speech. We do need to regulate harmful conduct.
So you're basically saying, and I agree with you, that we need to basically separate the idea that these people are protesting ICE from the actual violence that they are ensuing. So you think that the government mainly needs to focus their approach against these people on their conduct, which is the actual actions that they're doing, so that people who are more reserved can feel free to express their viewpoint?
Well, with the caveat that I haven't seen that particular news story or what people are doing, but I would say anytime there's property damage, vandalism, assaulting or battering people, or something that is clearly a crime in every single state in this nation, those laws need to be enforced, right? The rule of law is extremely important, and we rely on those protections so that we can have the non-harmful civil exchange and speech and protest.
Hey, thank you.
I know you had mentioned the Establishment Clause earlier, and concerning religious freedoms, I feel like one of the common topics of debate and discussion is the right, or not exactly the right, but the idea of the separation of church and state, which, and to the best of my knowledge, it's not strictly included in the Constitution or necessarily the Founding Fathers' rights for religious freedoms. So, but however, I feel like most of our, or a lot of the court cases I've seen recently are kind of swaying more towards a line of separation between church and state. Do you feel like these courts are going in the right direction, or that we need to reverse back to more of a constitutional view where the church and state, or the church is kind of permeating the government and not necessarily being banned from inclusion in the government?
Yeah, great question. You're right. It's not in the Constitution. It was in a letter by Thomas Jefferson to the Danbury Baptists. So I hope someday you'll come take my law and religion class at FSU Law, because we got to spend several weeks exploring this topic. You'll be glad to know, actually, the courts are going in the other direction. There was a period of time, sort of 60s, 70s, 80s, where the court was all of a sudden came up with this test called the Lemon Test, which said basically if the government does anything that doesn't have primarily a secular purpose, and that if anybody understands it as potentially an endorsement of religion or is offended by it, there were these cases about this Bladensburg Cross Memorial, it was a big veterans cross or 10 Commandments and so forth. Can you have legislative prayer? Those cases were very much erring on the side of the government can't do anything that even, potentially implicates anything religious. But more recently, you've probably heard about the Coach Kennedy case, where there was the high school football coach out in Washington who was praying on his own time after the game was over at midfield. And that was brought where he got punished. And is that the bell? Sorry. Okay. So he basically lost his job over that. And the school said it would be an establishment of religion if we let our coach and our teacher pray by himself on his own time on the field. And the court said, no, that's that's not what separation of church and state means, to the extent that that's even a valid concept. But hopefully I'll get to talk with you more about this.
Thank you.